if they've already, let's say, maxed out what they can give away during life. It's another way, it's like another level beyond just using your exemption to make that wealth transfer without any transfer tax consequences. This time a year ago, and I guess it would have been before the election, but essentially a year ago, all of our clients were saying, well, the high exemptions will expire at the end of 2025. What do we need to do in 2025? And we gave them the usual suggestions, things that you can do for lifetime planning. And then the election happens, and it's kind of like, oh, well, things may change, because we knew there's going to be a big tax bill that would have to go through in 2025, one way or the other, because there were so many important items in the Internal Revenue Code that were going to otherwise sunset. So we knew there's the big bill coming through. Personally, I was more expecting them to just repeal the estate tax entirely. I would not have been surprised, but they didn't do that. We still have the estate tax. So we probably will have it for a long time to come, but it will be at these higher exemptions. $50 million per individual translates into, if we're thinking of family wealth, 2 spouses, that means $30 million with proper planning can be passed down to other generations and totally free of estate tax. So the bottom line is there's not that many people left numerically that probably have to worry about the estate tax until Congress does something differently.
Correct.
And who knows what they'll do.
And the key is that this is made permanent, and it's not just through some budget reconciliation act, so there's no expiration period.
Right.
There would have to be a lot more action by Congress, as you mentioned, to be able to change this, this 15 million, which it gets adjusted for inflation every year going forward, just to be clear. And so now you said that there aren't a lot of, individual taxpayers who are going to be subject to and pay the estate tax ultimately. But there are still a number of them who do have a significant, net worth.
Right. And people who would like to be at that level to have to pay estate tax. And, we like to help people get to that level, and then we can plan for the taxes.
That's right.
But yeah, there's still, of course, significant people, business owners, any number of ways that wealth can be created that needs to manage it, and they want to try to pass it on, in most cases, to their families or to charity or whoever their interests are. And that's what hopefully we'll still have a practice to help them do that.
I don't think we're in any danger of that happening anytime soon. But I thought that we would spend a few minutes talking about a couple of estate freeze techniques for the clients that do have those substantial estates. And so one of the ones I wanted to discuss was a grant. Place assets into this trust. You can be the trustee of it. And by its terms, the grant pays you back an annuity, and it can be a varying annuity to some degree, but it pays you back an annuity. And if the value of the assets exceeds the IRS's hurdle rate, and it's a successful grant, then all of the excess profits above and beyond the...
That's a statutory interest rate.
Correct.
We talk about the hurdle rate.
The 75-20 rate. And so if the assets of that grant outperform that hurdle rate, then the excess profits can be shifted off to the next generation or any of the other beneficiaries you'd like without really having to use any of your gift tax exemption, because the value of the annuity interest that you've retained is pretty close, if not the exact amount of the assets that you put into it
right
at inception. Of course, you can't do this to help out grandchildren because of some technical tax rules, but you can at least
you can pass it down to the next generation. And it's all based on the performance of the assets. And depending on who's managing those assets, it can be an extremely effective wealth transfer tool. And as Tash was saying, it doesn't use up any gift tax exemption or estate tax exemption. So for wealthy clients in particular, if they've already, let's say, maxed out what they can give away during life, it's another way, it's like another level beyond just using your exemption to make that wealth transfer without any transfer tax consequences.
Yeah, but when you're considering grads, I do want to point out, aside from the limitation on trying to take care of grandkids right now, is you want to be mindful of cash flow. So if you have cash flow needs that you think are not going to be met because you've tied them up into this grad for a while, then you probably shouldn't do it, you know. And then to sort of mitigate against the risk that you mentioned of underperforming or not beating the hurdle rate, you know, my suggestion is you can replicate that grad, but have it in different sectors. So if one sector is pulling down the average,
right,
that's an unsuccessful grad. Doesn't matter. It
right.
comes back into your
just like a diversified portfolio.
Correct. So the question is really just how many grads do you want to do? And then if you get on a rolling grad program, you can, I mean, those successful ones can really be home runs at the end of the day.
That's true.
I think safely, without taking much risk, shift assets to the next generation. And if you're concerned about, well, I'm not going to have access to the profits anymore, you know, or at least my generation level won't, you can move those assets, if this is additional planning, have the profits sort of fall into a receptacle trust that your spouse is the beneficiary of, you know? And so, again, can't benefit any.
A spousal limited access trust, sometimes called a SLAT.
Mm-hmm.
Yeah, right, which is a very popular concept for modern estate planning because of the uncertainty of where the tax laws may go.
That's right.
And it's just in a nutshell, it's a type of a family irrevocable trust that can be unwound in such a way, or it can pass to the grantor's spouse, and then hopefully spouse and grantor on good terms, and it can end up back where it began if it looks like that's what needs to be done.
That's right. And before we leave this topic and go on to slats, which is where I think you're going to here in a minute, the only other downside to utilizing grats is the availability of fair market value and the ease of getting a valuation on some of the assets in there because of the need to pay this annuity.
Right. So it makes some assets difficult, like if you put a piece of commercial real estate in it.
Correct. It's going to be challenging, and there are going to be additional administrative costs in the form of appraisal fees that need to be factored into the equation. And so then the next question is, I think you were getting to this, is slats. What is this flexibility you're talking about, and why might someone want to infuse that into their irrevocable trust document?
Right. Well, I mean, the problem is in estate planning and in a lot of other types of planning too, asset protection planning, trusts are a valuable tool for the advisor. And the problem with trust, of course, is that in most cases, to accomplish what you want that trust to do, it has to be by its terms irrevocable. And a lot of people have difficulty with that idea of, well, okay, you're telling me you want to put all of my, substantially a large part of the wealth that I've created during my life into this trust that I no longer have any control over. And we say, yes, that's exactly what we're trying to convince you to do, because there's many good reasons to do that. As long as you have the right trustee, should not be a problem. However, it's a difficult concept for a lot of people to accept. So what estate planners, trust and estate attorneys try to do is build in flexibility into these trusts, even though they are by their terms irrevocable, they can be designed in such a way that it provides some sort of a mechanism to essentially undo it if that's what, the future, things change. It may not serve its purpose. There may not be an estate tax. There may not be creditor issues, whatever. How do you undo it? And the SLAT, the Spousal Limited Access Trust, is simply a trust where typically, I guess you would have a husband and wife, a family unit. The husband, let's say, creates the trust, funds the trust, provides that the trust will be for the benefit of his spouse and his descendants, and also provides, typically with someone who would be either a special trustee or maybe a trust protector, some independent party can step in, and if they decide, they could have all of the trust property distributed out to the spouse. And it's just the trust provides that. Doesn't have to be that way, but it can happen. And that's simply a very popular type of trust to use for clients who are, they kind of like the idea of planning with trust, but then they're not really sure if they want it to be totally beyond their grasp. And so it's a way, sort of a workaround to, if it ever needs to be back in that generation's hands, it can happen.